Unless they want to walk down the aisle, believe they can easily walk down.
Mr. Legua, please allow us to control my code. Which file is it? 544, 23. How will you organize? There are those who are supposed to be going out. Yes. Criminal case number E544 of 2023, Honorable Paul Ongili Owino, alias Babu Owino, Calvina Okoth Otieno, alias Gaucho, Tom Odongo Ogundi, Michael Otieno Mondi, Pascal Ouma, Kevin Wambo, and Willis Owino Baraka. Paul Ongili, Kevin Okoth, Tom Odongo, Michael Otieno, Pascal Ouma, Kevin Wambo, Willis Owino. Just have a seat. Mr. Legua, you had made us aware you were in this one.
Yes, Your Honor.
Are you in this one?
Yes, yes, and we can put the quorum. This is for the first and the second accused person. We have our senior Mr. Awele. Is present.
Sorry, Your Honor, I am present.
Okay.
We have Mr. Okach.
Present, Your Honor.
We have Ms. Asha Bashir.
Present, Your Honor.
We have Mr. Wilberforce.
Present.
Okello. And myself, Your Honor, appearing for the first and the second accused persons. You know, we also expect being joined by Mr. Danson Omari. He's in his way coming.
And the rest. Yes.
In the matter, I am Nyangayo.
Yeah?
Nyangayo. Here with Mr. Omude. For the third, fourth,
How are we organizing ourselves?
fifth, and sixth accused person. Mr. Mabe is present for the seventh accused person.
Thank you. Thank you. Miss Madam Jacinta.
Good afternoon, and may it please the court.
Yes.
My name is Jacinta Nyamosi, Deputy Director, Public Prosecution, together with my colleagues, Mr. Riungu, Mr. Owiti, Ms. Judy Chepkir, and Mr. Gashoka, appearing for the Republic, the prosecution.
I'm looking at the time, and we have to agree on one thing before we proceed on. We know the normal court working hours, not beyond 5 p.m. So we have two options. We can proceed by consensus, or we stop here and proceed tomorrow. I don't know. We'll hear from one person from each side. I don't know who is the senior most defense counsel here.
Yes, thank you so much, Your Honor. Maybe before we proceed, my learned senior, Mr. Omari, Danson, he's always early, but today is a bit late. He's for the first and second also. He's part of the team.
Okay.
Madam President, sorry, I was in Shan's report. I've just come in for this matter. That's what I was saying.
Your Honor, without taking much time, we really hope that there can be consensus. We just proceed. My learned colleagues are always ready to proceed, and I believe we can have consensus.
Okay. Now, Madam Jacinta.
We are ready to proceed, and I would agree with my colleagues that we proceed.
Okay. Thank you. Is there anyone who doesn't understand English language well? Kuna yeyote ambaye haelewi Kizungu vizuri? Okay. So we can proceed in English. Na tafadhali wale ambao wanapiga picha, nafikiri picha moja, mbili, tatu inatosha. Nyuso ni zile zile tu. Sasa naomba tu mtulie, sawa?
They've said they're okay in English.
Pardon?
They're all okay in English.
Yes.
The charges are Mr. Paul Ogili, Owino, alias Babu Owino, Calvina Okoth, Otieno, alias Gaucho, Tom Odongo Owudi, Michael Otieno Omondi, Pascal Ouma, Kevin Wambo, and Willis Owino Baraka. You're all charged with conspiracy to commit subversive activities contrary to section 77(1) of the Penal Code, and on diverse dates between the 7th day of July 2023 and the 18th day of July 2023 within Nairobi City County, jointly with others not before court, conspired to commit subversive activities, activities which are prejudicial to public order. Is it true or not true, Honorable Paul Ogili Owino, alias Babu? Yes, ma'am? Not true. Calvina Okoth Otieno, alias Gaucho? Not true. Tom Odongo Omudi? Not true. Michael Otieno Omondi? Not true. Pascal Ouma? Not true.
Kevin Wambo?
Not true.
And Willis Owino Baraka?
Not true, Your Honor.
plea of not guilty is entered for each of the 7 accused persons, and the defense to be supplied with copies of witness statements and documentary exhibits.
Okay, we just supplied Yona.
Just a moment. Madam Jacinta, I need a confirmation from you. Do you have any issue with bail bond?
Yes, that is the position we have. We have filed a notice of motion application. And I'm supporting affidavit.
Where are you?
Currently awaiting this house. Yeah, all the accused persons are entitled to have one.
Yes, Madam Jacinta.
Your Honor, before you is a notice of motion application brought under Article 24, 25 and 49(1) F, G, and H of the Constitution of Kenya.
Slowly, I'm writing manually. Brought under Article?
Under Article 24, 25, and 49(1) F, G, and H of the Constitution of Kenya.
Sorry for that.
Not a bit of it's also brought under Section 36A and 123A of the Criminal Procedure Code, Cap 75 of the laws of Kenya. We also rely on other enabling provisions of the law. The Republic applicant will be seeking to find that will be seeking and praying that this honorable court finds that the prosecutor has established compelling reasons to deny each and every respondent. Your Honor, this application is premised and support.
To deny the respondent's vote?
Sorry?
Deny the respondent's vote?
We'll be relying on the.
Sorry, it's a statement you left handed.
All right. Maybe you can clarify.
This is the Republic applicant will be praying that this court finds that the prosecutor has established compelling reason to deny each and every respondent
bail. This application is supported by the sworn affidavit by Corporal Geoffrey Mwangi. Corporal Geoffrey Mwangi, number 75579. Your Honor, the facts that have been laid out in the said affidavit support our application opposing bail. I wish to draw your attention, of course, to the whole affidavit, but I will draw your attention to particular paragraphs of the supporting affidavit. Paragraphs 3, which indicate that there were intelligence reports which were very clear and are apparent to indicate that the respondents were planning unlawful meetings. 1. That there was sufficient belief that the respondents were going to interfere with the security of the country, and that if left free, they are likely to cause more harm to the security of the country. I also wish to draw your attention to paragraphs 7, 8, and 9, and 10. Emphasis with paragraph 10, which indicates that investigations are actually ongoing and if the respondents are released, they are likely to interfere I also wish to point out to paragraph 11 that investigations have indicated that investigations are still ongoing. There is a likelihood that additional charges may be preferred against each and every respondent. I invite Your Honor to actually have an opportunity to peruse the whole affidavit And it's my submission that there are compelling reasons to deny bail to the respondents. Your Honor, I would request this court to briefly allow my colleague, Mr. Yung, to highlight some of the issues on law so that we can be able to finish our submission. Thank you.
Mr. Yung, how long will it take?
This is less than 5 minutes. This is to highlight the authorities that we intend to use to support our application.
I don't think we should go beyond 6. So if you take shorter time, it's better for us, so that we finish early, not at night.
Agreed.
Yes.
Thank you. Your Honor, not to belabor, the prosecution, Your Honor, relies the authority of the Public versus DKN. This is an HCC reported case at EMBO number A007 of 2021. Your Honor, and the gist of this particular authority that we are relying on, the prosecution is supposed to lay a basis and provide the compelling reasons that would require bail bond to be denied to the accused persons. Your Honor, the nature of our application and the ground that we are relying on is that there is a likelihood that the accused persons, Your Honor, will continue to commit this particular offenses, this particular offense that has been read upon them. Your Honor, I do not need to belabor that the first accused person, Your Honor, is an honorable member of parliament. And one of the places where continuous demonstrations that have turned and have led to destruction of property, obstruction of ordinary course of business going on, is Jacaranda. Your Honor, the other respondents, Your Honor.
Just a moment.
The other four accused persons, Your Honor, are individuals, Your Honor, whom have previously, especially for the second accused person, been charged with offenses that are related to coordinating unlawful assemblies taking place, which have led to destruction of property. And therefore, Your Honor, what the prosecution is praying for this court is that the compelling reason here is that even as we talk, or even as we submit before this court, there are certain acts of distractions that are ongoing.
Your Honor, I hate to interrupt my very good friend Mr. Riungu, but you have limited time, and Mr. Riungu is actually giving evidence which is nowhere in the affidavit, and I know he knows that. I've tried to sit down, but my seat is becoming hot. I think let him just restrict.
You know, I've had my learned colleague, and you know, it is the hotness that we are stating that it is a compelling reason, Your Honor, that the court should consider. Secondly, Your Honor, the other, because of the limited time I have, the other I on is the authority reported in case number A031 of 2021.
Case number
031 2021. Delivered by Justice W. Coril at the High Court in Incommunicado. You know, also in this particular authority, it is a submission that, again, one of the compelling reasons that and which is cited on the second page is that, again, where the accused persons are likely to commit further offenses. And secondly, where the accused persons, Your Honor, are likely to obstruct the cause of justice. Of the Constitution, the right to deny under Article 24, the right to liberty is one of the rights that the court can't curtail and limit, since it's not one of the rights that have been provided for under Article 25. And therefore, Your Honor, due to the Constitution, the time that we have, we are praying that when you retire, that you look at the principles that the court highlighted in these two authorities to grant the prayers that we have called for and prayed for. That is all.
The other authority. Yes, Mr.
I'll just have a little address, then I'll invite my learned friends to address you on some few aspects. I will address you on the I'll address you on the aspect of the pre-arraignment detention in respect of the first accused person, to which the prosecution is guilty of, and further guilty of the duty of non-disclosure. You know, the first accused person was arrested on 18th at 0900 hours, that is 9 p.m. at JKIA when he was en route from Mombasa.
On
18th at 9 p.m. or thereabouts. He was then taken to, driven all the way to Kirinyaga County and detained at a police station called Wanguru Police Station. To make any contact to either his family members or his advocates. He spent the whole day there. Never ever even informed of the reason for the arrest. You know, I am addressing the violation of Article 49 as I address you. He was denied right to access to counsel. And most fundamentally, he was denied the right to be produced before a court of law within 24 hours. This is a time at around 5 o'clock that 5 o'clock on the 20th of July that the accused person has been able to see a judicial officer or to appear before a judicial officer. There's no explanation that has been adduced why all that transgression had to take place. And it's always the duty of a trial court it's always the duty of the trial court to inquire on that particular aspect. As and when the same is brought to the attention of the court. You know, pre-arraignment detentions were outlawed, and Article 51 speaks to that fact. And the case in the High Court in the case of Musa Bwagwa versus Mwanasi and 9 others versus Chief of Kenya Defence Force, EKLR.
The case of
Musa Mwabwaga, that is MBWAGWA Mwanasi and 9 others versus the Chief of the Kenya Defence Force and others, 2021 EKLR. That aspect of pre-arraignment detention was addressed. And the High Court said it was unconstitutional. And therefore, a charge that is premised on a violation of the Constitution, the court ought to interrogate. The integrity of that charge and the propriety of that charge. Even in the affidavit that they have brought before you, they have not addressed that aspect. As I pen off, the court is called upon by Article 23, by Article 3, to defend this Constitution. Article 10 enjoins the court to uphold the Bill of Rights and the rule of law. Article 27 enjoins the courts to ensure, Article 27 enjoins the court to ensure that there is equal protection of the law, equal enjoyment of the law, and equal benefit. And I'll close. We need an answer. Why was Honorable Babu Owino not brought before court within the prescribed period? Number 2, whether a charge that is premised, the answer that we are seeking is why he was not brought before the court as decreed by Article 49, clause 2F. Number 2, whether a charge that the Constitution has legal propriety, and whether the same can be the premises for denial of bail or bond. Mr. Okachi will address you.
Yes, Your Honor, I will start by indicating, Your Honor, that it is true that actually not only the first accused persons, but all the accused persons, Your Honor, are being arraigned before you, Your Honor, outside Your Honor, the 5th and 7th accused persons were arrested on Monday, the 7th day of this month, 2023. So that we are just shy of the 5 working day period, with the 6th and 2nd accused persons being arrested on the 18th alongside the 1st accused person. Your Honor, we will not belabor this fact because we will pursue it at the High Court in terms of the violations, Your Honor. But that is important because it tells you a lot as to why we are even addressing you at this time, Your Honor. Your Honor, what has happened, and in a nutshell, there is a skit that has been written and Your Honor, the duty of the investigators and with a lot of respect to the battalion of prosecutors, senior prosecutors, is just to ensure that these accused persons fit that skit. Your Honor, there is no iota of evidence that has been placed before you either through their affidavit, Your Honor, or the oral arguments that suggest that there is any complaint whatsoever. Your Honor, if you look at what they have attempted to indicate as compelling reasons, Your Honor, and that is from paragraph 7. Your Honor, you will see there's a repeated use of the word reasonably believed. Reasonably believed. But you are not being told, Your Honor, reasonably believed by who? To sustain this particular very heavy averment. Who is this who is reasonably believing, and on what basis? You do not have that. Your Honor, in fact, maybe this may not go on record, but this is the first affidavit I've seen from, HSC Victor Juma Witi that has no annexure at all. The very first one, I've never seen. And that tells you there's nothing. Witi can never do such an affidavit. There's nothing. They are telling you.
You don't have clarity on record. It's done by the investigating officer.
I take that.
Very telling.
It is okay, Your Honor, but you'll read it for yourself, and I do agree he cannot do such. However, Your Honor, you will notice that even on the substance of the charge,
Sorry.
Your Honor.
He has the same name.
Yes?
He has a similar name.
it is my learned colleague. But he has clarified, so I'll leave that point.
Okay.
But Your Honor, if you look at even the charge itself, to show you how they have actually stretched to the point of breaking a backbone. That is what the prosecution has done. Your Honor, they are telling you in very good English that these events happened on the 7th and on the 18th day of July. 18, 2 days.
On which days?
On the 7th day of July and the 18th day of July. That is on the particulars of the offense. And Your Honor, they are telling you further that these events happened at Kamukunji. Your Honor, they have, and this is common knowledge even to them, they have admitted that Babu was, the first accused was arrested at JKIA. On the same 18, at around 10, because he landed at 25 hours. So, Your Honor, the question is, do we have two Babu Owinos? Does he have a clone that was at Kamukunji that day? Your Honor, I'm table for the court's eyes, the ticket that says clearly he was landing at 21:25. Your Honor, if you look at further to demonstrate the fact that there is no compelling evidence, and indeed, even the substance of the charge is something that the court ought to look at in admitting the accused persons to bond. Your Honor, I'll refer you to paragraph 7.
Yes,
Your Honor, they are telling you, and my learned friend Mr. Ringo has told you that ticketing, especially where the first accused person represents that constituency. So that is a compelling reason you are being told. Your Honor, there is a decision or a ruling by your brother, and that is the Honorable Justice Mogambi. Your Honor, that is in the case, if I may, in the case of Edwin Sishanya Amboso versus LSK and 4 others. We have provided that to yourself and to the prosecution. That is HCC petition 255 of 2023. Edwin Sishanya Amboso. Your Honor, it says in order that it is the responsibility of persons who have announced and organized the said demonstrations to provide guidance and leadership to the participants. Your Honor, the first accused person is not even a principal in the Azimio coalition. He wishes he would have been, he's not. And there is no evidence that has been given that he organized any of these protests. Which in any case, Your Honor, remains legal.
Just a minute.
It remains legal because your brother declined to injunct the said expression under Article 37. Your Honor, other authorities must deal with individuals. Acts of violence or destruction of property are personal crimes. So it cannot be a crime where vicarious liability, like the prosecution is trying to adduce. Your Honor, the charge that has been preferred, Your Honor, the history of this charge is very important, and I think this court will bring this matter to a rest. Your Honor, the Section 77(1) of the Penal Code, Your Honor, was brought into our laws, Your Honor, in 1960. It didn't originate from the Britons. It's something that was brought here by the Britons themselves. It wasn't in their own laws. And the purpose of that, Your Honor, it was to deal with the Mau Mau freedom fighters. That was the purpose of this particular section that the DPP is actually telling us to use today. It was to suppress. So that is what this court is faced with in those days. And those people who never wish this country to get independence. That's exactly the essence of this charge. And you will not find even authorities. I think people have been shy to use this section. You will not find authorities in terms of these sections. Courts have been shy, prosecutors have been shy. But today, we are the day where it can be brought in broad daylight. We will deal with it, Your Honor, at a different forum. As I finish, Your Honor, Your Honor, I will heavily beg you, and that's why I'm trying to limit these submissions, Your Honor, to know that the first accused person, and I believe even the rest, but for him, he has not eaten, Your Honor, not taken water, 3 days. And because of where he was held, Incommunicado, 3 days, Your Honor. Even Mackenzie was fasting, was eating. The Constitution and the people of Kenya to give us the chance, Your Honor, to enjoy that. He's not at a flight risk. He's an honorable member of Parliament, as indicated by Ryungu. Those are the words he's used, honorable member. And the rest are equally Kenyans. They will come to court. You can put conditions, Your Honor. They will abide by all that. They are willing to abide by all that. Your Honor, lastly, the first accused, Your Honor, is not well. He's actually not well, and I wouldn't want to take a lot of time. He's been denied access to medicine, which he was taking, and I'm so sure he needs to go to hospital after this. So we'll be begging also that that is considered, Your Honor. He has a special physician who sees him at Nairobi Hospital. That is all, Your Honor. Maybe my sister, just for gender balance, if you give her just 1 minute, we are trying to limit.
Thank you very much, Your Honor. There's a maxim.
Sorry, just a moment. Mr. Okach.
Yes.
You are saying that somebody has not taken water for 3 days.
Yes. He has not taken water for 3 days.
How did you know?
Yes?
How did you know?
Pardon?
Yes, told us.
Oh, sorry, how did you know?
I've actually, we went to Anguru police station in the morning. We were there even yesterday. We were dispersed. Even advocates couldn't access. But today, I've been with him at the basement cells. That's the first time we've been able even to access him. That's how inhuman this has been. He has not taken his ear, he can talk, and I've confirmed that from him. And I believe...
So you... Just a moment. Did you give him water yourself?
Yes. Your Honor, the conditions down there, and I really empathize with the officers here. There are strict instructions. Even for us to gain access, it wasn't that easy. I even tried to call my colleague. Ryungu is very good at helping us in those issues. But
Your Honor, we attempted to carry water from the gate. You could not be allowed to come in. I'm sorry. You would not be allowed by the police officers to come in with anything.
It's okay. I just wanted to find out why he's talking about it here.
What Mr. Okach is not telling you is Babu Owino has been shakaholat for the last 3 days.
No, but there was also a tweet that the Kajiro said that the police officers treated them very well. So I'm wondering what measure of treatment is it? No, we did. 1 minute here is saying they're not real, but he tweeted and said the officers were very professional.
Your Honor, I'll deal. No police officers are my client. I'll deal.
Of course, it's all.
I'll defend
I should have let Ms. Bashir continue.
Thank you very much, Your Honor, for the protection and guidance. The 2010 Constitution that was birthed in this country is one of the best documents we have in the country. The act by the prosecution is actually to more of mutilate than safeguard, and we ask this honorable court to safeguard the interests, especially of the accused persons, in line with Article 49 and also Article 50, which gives the right to fair hearing. There's a maxim that says, he who comes to equity... Sorry.
He who comes with
must come with clean hands. And I wish to submit that the prosecution has not proved that they are coming with clean hands. From the time the first accused person was arrested to the time he has been presented to court, he was denied the right to representation. He was denied access to the basic fundamental rights accorded to each Kenyan. The prosecution, in their own domain, have judged the accused persons and decided to be the judge and the jury. Your Honor, the accused persons, like you've been told by my colleagues, have not been able to eat. Their whereabouts, especially for the first accused persons, was not clear, even to his legal representation. We have been to different police stations from the time he was arrested. And the key question to the prosecution thus is, an accused person has rights safeguarded in this constitution. Why was the Honorable Babu Owino kept away from his legal team as enshrined in the Constitution? Why was the family not made aware of his whereabouts? And why was he not arraigned in court as per the Article 49F, which talks clearly on the procedures on how to deal with an accused person? Therefore, it is my humble submission that
just a moment.
The prosecution have not proven to come with clean hands, like I said. It took them from the time they arrested the accused person to today at 5:20 to come up with this affidavit that is full of assumptions, innuendos, and presumptions. If you look at the affidavit,
Your Honor, just for guidance, I don't like interjecting. You had directed and indicated that we should have been done by 6, so the prosecution ended up being curtailed. So we just need direction whether there's a new way just to continue with the time.
She's waiting up.
She's waiting up.
As she said, equity comes, who comes with equity?
equity must come with clean hands.
So even as we require equity, Your Honor.
Yes.
You can sit for us to reply.
Madam Bashir, everything that is being said is going on record, so you may not need to repeat
Yes.
what another council has already said.
Okay. Much obliged, Your Honor. So, in parting short, my humble submission to this honorable court is that the accused persons are not at flight risk, and that the affidavit presented before this honorable court does not prove or necessitate reasons why they should be denied bail, And therefore, I request this Honorable Court to protect, uphold, and safeguard the 2010 Constitution. Thank you, Your Honor. I would like to call my senior, Awele, to wind up.
Yes, sir. Mr. Awele.
Yes, Your Honor. Thank you so much. I will not take too much of your time, Your Honor. I appreciate that you have spent so much of your time already for the day. Except that what is before you, Your Honor, is a very fundamental issue that goes to the heart of rights that are guaranteed and protected under the Constitution of Kenya and under the Bill of Rights, no less. That bill, Your Honor will appreciate, is not just an ordinary chapter in the Constitution. It essentially is the heart of this Constitution. You violate any of the provisions of that chapter, you essentially snuff out the life of this Constitution for all we know it to be. And I say that, Your Honor, with great respect, because as a practitioner, as an officer of this court, which I believe Your Honor has been before ascending to this very hallowed position in the judiciary, we have a duty, Your Honor, to enforce and uphold and defend this Constitution. And in the course of doing so, particularly with the division of labor within our courts of law, as you deal with these questions every other day, Your Honor, sometimes the detail of it and the weight and significance of some of the provisions of this Constitution may be lost.
Don't worry, when I give it the political angle, it cannot be any other intelligence, artificial intelligence. That's the answer.
And most of the time, inadvertently. And I say that, Your Honor, because it is now becoming a norm that agencies that have been created under this very Constitution and under the terms and conditions enshrined in this Constitution are now repeatedly and so brazenly violating cardinal they are repeatedly, Your Honor, and so brazenly violating cardinal provisions of this Constitution that we as a people agreed will determine the relationship between those whom or to whom we delegate authority to exercise on our behalf. And us or we the people, and between those agencies intersect. They are violating the common bond. And that is very critical and important, Your Honor. It is critical because as I started my submission, this Constitution is the lifeline of the existence of this country as a nation state. You snuff life out of this Constitution and you invite chaos and anarchy in the manner in which we coexist. And so, the violation of this Constitution, particularly by those to whom we delegate authority, cannot, and my Lord, cannot, this must be taken very seriously, cannot be taken lightly. And that is why I said, as I started, Your Honor, and I said it with utmost humility, that in the course of our ordinary practice, particularly before these specialized divisions of the court, it is very easy to lose the detail, the weight, the significance, the nuances, the detail, the significance, the nuances. Of some of the provisions of this Constitution as we intended them to operate. So that, Your Honor, it has now become a very sickening trend that police officers, despite express mandatory provisions of this Constitution that proscribe the holding of detainees for more than 24 hours without compelling reasons, will very comfortably appear before you hours after hours after they have violated a mandatory provisions of the Constitution and present an accused person before you, and then without batting an eyelid, ask you for permission to hold them for even a longer period of time. Your brother, the Chief Justice Emeritus William Mutunga, coined it very interesting. The Utadu attitude. that an agency created under this Constitution, exercising powers under this Constitution, presumed to be aware of the proscriptions and the prescriptions of this Constitution, can violate it and then come before you and ask you to perpetuate that violation by granting them more time to hold accused persons for an even longer period of time. Your Honor, before you are just these two documents. Your Honor, there's a charge sheet. And there's an application to hold these accused persons for a further period of time, and specified time for that matter. You can see the mischief. They're even asking you to just grant indefinite leave for them to hold these accused persons for an indefinite period of time. And Your Honor, just scan through these documents. Not a single explanation has been attempted for why these gentlemen are being brought before you more than 24 hours after they were arrested. The Inspector General of Police has not bothered to provide the Director of Public Prosecution with any reasonable explanation, or any explanation for that matter, why these gentlemen were held for that long, and the Director of Public Prosecutions, who under this Constitution is supposed to exercise.
Just a moment. How many more minutes?
Your Honor, can I take just 10 more, please? But Your Honor, at the heart of these submissions before you is the freedom of gentlemen here who have been held incommunicado for more than 24 hours. I think they deserve just that extra 10 minutes. Your Honor, the Director of Public Prosecutions, an office created under this Constitution, who is supposed to exercise independent oversight as a countervailing measure deliberately created by this Constitution. Has approved a charge sheet.
Yes, no, most of them are ready. Yes, I'm trying to get some more common papers so that we can be able to sign all of them once. Yes.
Yes, has approved the charge sheet, Your Honor, which does not, in fact, has not only approved the charge sheet, has actually caused to be drawn an application to detain the accused persons and therefore perpetuate violations against the Constitution without even bothering to inquire from the Inspector General of Police on whose behalf these accused persons were arrested. Why have you been holding them incommunicado for more than 24 hours? And that points to another lapse in the respect for and enforcement of the Constitution of Kenya, which I have in my remarks earlier said pose grave danger to our continued existence as a rule of law country. What does the DPP do instead? They also brazenly even attempt to fill the gaps for the DCI or the IG by even attempting to adduce evidence from the bar. Evidence that is not even in the affidavit of the corporal who purportedly has the knowledge of first-hand information for why this accused person should be held any longer than is necessary. Where does that leave the policy or constitutional objective for why the DPP was created as an independent office to check the Inspector General of Police in the discharge of his mandate? A danger, that is a danger to the common bond that I alluded to, that this court must guard against. And my Lord, all that I have said summarize into this very simple submission. We are before you seeking reasonable bail terms for this gentleman, the accused person. Your Honor, does the conduct of the IG, does the conduct of the DPP count for something as you consider my learned friend, Ms. Asha Bashir, has submitted to you that he who comes to equity must come with clean hands? The conduct of the DCI, the conduct of the DPP that I have outlined in very brief terms before you, does that, Your Honor, count for something? Does it hold any weight in your decision or in your consideration of the application pending before you for the detention of these accused persons for a day long? It surely must. The misconduct that I have alluded to is not just any misconduct. They are violations of the Constitution. Article 2 is very clear in that regard. Any violation of the Constitution, they may not have any fatal effect to the charges before you, but it surely must have some effect and weight on your discretionary powers in considering an application for bail and for bond. That said, Your Honor, the law on bail and bond applications is fairly well settled. and I will not rehash that law or the principles that are applicable, save to invite you, Your Honor, to always bear in mind the policy guidelines by the NCAJ on bail and bond of 2015, and in particular, the purpose or utility of bail in a criminal prosecution such as this. That utility, again, Your Honor, is fairly straightforward, and I will not rehash it. I just want to emphasize on one point, and that is the burden of the prosecution in demonstrating compelling reasons. Compelling reasons why an accused person should not be denied bail or bond. Again, it is fairly well settled, Your Honor, that that burden reposes in the prosecution. Only shifts to the accused persons where compelling prima facie reasons are demonstrated to your satisfaction. Your Honor, compelling reasons are questions of law and fact, and therefore can only be presented to you either by evidence or by reference to specific provisions of the law to justify the application of the order sought. Allow me to concentrate on just these two documents.
Just a moment, just a moment.
Most obliged.
I have tried to limit time so that we do not sit at night. Hours of darkness begin at 6:30. It's now 6:40.
You know, we've sat here up to 4 in the morning.
Let me finish. So we are going to stop at this point. Whatever submissions that are remaining, because we will not finish today. Because we are at Mr. Welle, this side.
We donate our time to Mr. Omar.
And the president.
And then now Mr. Riungu and his team have to respond.
We can take 7 minutes in
Sorry,
response.
let me finish.
Yes, Your Honor,
So it is
from the 6th and the 7th, I donate the time to my seniors.
So it is getting dark and we have a crowd inside the building. I know you don't work here, but there's a danger in keeping this large number of people within the court premises at night. I have tried to control Mr. Welle, but he's going on and on, so I
Your
cannot
Honor,
stop him further.
I would not want to be the one to hold this gentleman here for any longer. I am happy to take your directions on how you wish to limit my time.
What I would prefer is that if you are likely to take
I'll take the time you donate, Your Honor.
another period of more than 5 minutes, then it is better we stop at this point and we continue tomorrow.
No, I'll conclude. I'll conclude. Within those 5 minutes, I'm
You are sure you have covered all the areas you wanted to cover?
Your Honor, in the interest of the accused who have been held for so long, I will do less than 5. I'll limit myself. If it gets to 5, just cut it out. Yes, I will take less than. Yes. Let me just conclude the point that I was trying to make, Your Honor. So, Your Honor, the compelling reasons that the DPP provides can only be gleaned from these 2 documents before you. Very briefly, Your Honor, please refer to the charge sheet as against the application before you. Review that charge sheet. The offense that the accused persons have been charged with against the offenses for which the prosecution now seeks to hold them are diametrically different. You have been told, Your Honor, that the accused are likely to be a danger to witnesses. Your Honor, look at the charge sheet. All witnesses are police officers. They are all police officers. I will not belabor the point. You have been told that the accused persons are a danger to national security. That submission has come to you from the bar. No evidence has been adduced to back it up. But nonetheless, Your Honor, there are certain presumptions that this court cannot lose sight of. And some of those presumptions are in this Constitution. The security apparatus of this country follows a very clear structure created under the Constitution. It is for the DPP to demonstrate why he believes that these accused persons have the machinery or capacity to undermine why it has not been demonstrated to you why these accused persons or how these accused persons will undermine the entire fabric or structure of that apparatus as created and contemplated under the Constitution. In the interest of time, Your Honor, I'm pleading with you as demonstrated by my learned friend Mr. Okach. These are Kenyans. Unless and until they are convicted of the offenses for which they have been charged, their constitutional rights under the Bill of Rights, and particularly the presumption of innocence, persists and are not suspended by the mere fact that they are now seated on that dock. Grant them reasonable bail terms. As your learned brother, Justice Mugambi, intimated, they cannot be incarcerated because certain individuals have broken the law out there. For those reasons, Your Honor, we pray that you disallow the application and allow these accused persons to reasonable bail and terms.
On behalf of the other accused persons, I'll take strictly 5 minutes. I'll not mention any law. My good friends have mentioned the Constitution. I'll only bring the context that brings them here.
Okay. Just one moment. Yes, Mr. Omar.
Thank you. Then the very first one, I'll base all my arguments on Article 27 of the Constitution. Non-discrimination. With the following 5 points. All the 7 accused people come from one political party called ODM. Secondly, Your Honor, they are members of Azimio. Third, they are all politicians. Fourth, they all come from the Luo ethnic community. Fifth, Your Honor, this is a proper ethnic political profiling.
Your Honor, with all due respect.
They'll have time.
You'll have your time to respond. You'll have your time. Right, sit down.
Relax. I said 5 minutes, I've only 2 minutes.
Don't interrupt.
Your Honor, this affidavit has no date, that's the second line, when it was sworn. This affidavit is as old as 2017. It is the same affidavit that was used to arrest the ruling class now. From 2017 to 2022, it's the same affidavit. And all those that were charged based on this affidavit, their charges were withdrawn. The court should take judicial notice that the same police officers who swore this affidavit came to court and said they were forced
So your objection, that line with respect.
That is judicial notice of it.
The officer that default to this affidavit is before court. I haven't seen him ask Mr. Omari to talk about on his behalf. We just pray that that last line be ignored.
You know, Your Honor, it is me who represents them when the DPP wants to charge them. I'll give you specifically to the officer who swore the affidavit for the Deputy President. When that affidavit was disowned, the officer came to court and said he signed the affidavit under duress. It's specific and it's on the court record. So,
our clarity is that for purposes of today, the IO that swore this affidavit is before court. He has not spoken to Mr. Omari. Mr. Omari might have done very well in other cases, but this affidavit has not been said to have been sworn under duress. That's the only clarification I'm making. For today,
you know, I'm giving Mr. Whitty the perspective that come 2027, the same will be disowned, that it was signed under duress. For now, it will not be disowned. So that the court, as it is, it looks at the whole political context. Lastly, Your Honor, on this affidavit, I want to bring to the attention of this court that it is only the judiciary that is going to protect Kenyans. A great responsibility is on this independent arm. The political dwells outside should not be criminalized. And we urge this court to see far and remove the political contests from criminal issues. This is a political matter before you. Deal with it the way it is. So, Your Honor, out of that 5 minutes I've finished, I allow the President of the Law Society of Kenya, before he removes me from the role of practicing, to talk. Okay.
Let me see it. I wanted you to see this affidavit is the same what Chunga used. Chunga was not there. I wanted to bring the contest.
Your Honor, with your very kind permission, I recognize the predicament. Yes, but
I know it's not normal to.
His Excellency, the President.
Let's see what is happening, Your Honor, in this court.
Just give you a few minutes, I sign this.
Okay.
I have so much to do.
That's in order.
This is the political contest. The mobilization of the state.
And the profiling, all these are rules. No, watu ni wabaya sana. Wanafanya and Jurekani ni vipita hivi. Angalia. Kwanza vile wanataka kutoka. Wanafanya video tunakuwa sori na mgeni wetu. Sori tuonekane. Yes.
Even the nice changes of the name of the people.
Yes. They changed the name. This affidavit will be used in another case. It's wrong. It's in the article of the matter profiling. That's the profiling I was telling you. The magistrate. She's illiterate. Legally illiterate. We are back to the earlier. Meletewa chunga tena. Yes, I wanted you to say that.
I'll address it properly when I'm after. Because that's my fault. That's my fault.
Wengine watu wamekaliwa na mawakili sana. Mbona wakili hapa hajaongea kitu ya maana? And they brought their best bet. Sinaona kani retweet 5 o'clock ndio na wasubiri na retweet. Yes. You're not. You can provide a community. You can take a case.
Yes, Mr.
Very, very brief remarks on behalf of all the accused persons.
Are you comfortable submitting at night?
5 minutes at most. My colleagues have already submitted on the law and what is before you. Envy in the position you find yourself. And neither do I envy the position that the prosecution finds itself. Your Honor, by the prosecution, is to employ unconstitutional means the whole purpose of Article 49 and Article 50 of the Constitution is to uphold the dignity of the human person and also to uphold the dignity of this court. So you're right, it's my humble submission that should you in the manner in which it has been presented, in which all the accused persons were arrested and treated, then, Your Honor, you will undermine the dignity of this court. Your Honor, this court
to not only uphold the authority of the Constitution, but to also give confidence to the Kenyan people that in the Republic of Kenya, in as much as I said that I may not envy the position you find yourself in, I think that what is before you is a very simple duty. To the police, to the prosecution, to the country at large.
Just a moment. Do you mind if I interrupt you again? Just another 2 minutes to be done.
Oh, thank you.
Yes.
Yes, Your Honor, I was saying that through their pronouncements, and so therefore, Your Honor, I submit that your duty to the prosecution, to the police at large. That these courts intend to remain and that any infractions on the Constitution. But I say this because we are witnessing a dangerous trend of suspension. These courts speak. There will be no one left to speak for all of us. To release 5,000, not more than 5,000. So that they can go. Because these proceedings constitutional impropriety that we have to waste precious judicial time I therefore join hands with all my colleagues and beseech this court and to release and to affirm to these accused persons that they will always be protected and affirmed by this court. Your Honor, I thank you for understand that these are extraordinary times, and so they do call for extraordinary measures. And Your Honor, I thank you. If it is possible, Your Honor, we would be happy to have your decision now. But if it is not possible, because we understand that we would be more than happy to have your decision early tomorrow morning. It is important that they be remanded in a police station. Your Honor, I'm also being informed, and this is just for purposes of serving on time, I'm also being informed that the first accused is unwell, to their advocates to see their clients and the members of their family not be curtailed. Your Honor, I thank you for
Mr. Yungu, I made you rush, and then I tap run for the defense. I'm not sure I should limit you again. Let you proceed. But just an indication, how long will you take?
You know, because of the abundance of kindness that we've had, our landed colleague, Mr. Witty, is going to respond, and
he had indicated earlier 7 minutes. I think we got additional 3 minutes of the submissions, including that have been made by a president. So, really mind is getting 10 minutes.
Thank you, Your Honor. I will undertake to do under 10 so that I don't keep my seniors here, including my president, who today seems to have forgotten. Having said so, Your Honor, we have listened carefully to submissions from our learned colleagues for the defense, and we understand where they come. I am reminded that I should go slower than my usual issues. When I was indicating to court that has been on alleged, and the word alleged is chosen deliberately, alleged violation of fundamental rights and freedoms. My submissions will start from that point. And our invitation to this court is that when you whether the respondents should be released on bail pending hearing and determination of the charges before you. At this court,
just a moment.
And that rule applies also to independent issues before you, is whether or not this honorable court can entertain, hear, and or determine which Your Honor presides is defined and prescribed by Section 8 of the Magistrates Court Act 2015 on human rights. And that section says questions of alleged violations of Articles 25A and B.
Just a moment.
Articles 25A and B. And that means legal representation, the alleged violation of the right to food, the alleged violation of the right to discrimination, right against discrimination, which was raised by Malachi 27, all those fall out of your jurisdiction. And you cannot hear, in fact, in normal expectation, it would have been that the submissions on those points. You cannot hear and you cannot make determination around them. This is not to say that the ODPP, whose jurisdiction forum for that determination, the forum for such a hearing is outside your mandate, and they cannot be the basis of your consideration. For the avoidance the jurisdiction to hear and determine questions of alleged violation of rights and fundamental freedoms belongs to the High Court of Kenya. 165. Related thereto is the jurisdiction to hear and determine any question as to whether any law is in violation of the Constitution. My learned colleague, Mr. Okach, tells you that Section 77(1) of the Penal Code was used in an outdated law. We may agree, probably. However, it still forms part of the Penal 63 laws of Kenya. And more importantly, you have no jurisdiction to determine the constitutionality of Section 77(1). That aspect cannot form the basis of your determination on board. However, Your Honor, for completeness, sorry. For completeness on the question of jurisdiction, if, and this is an if, even if the of alleged violation of rights outside Article 25A and B, and therefore could find or make a finding that there indeed was a violation of the rights of any of the respondents. Even if you could find that there indeed was a violation, Your Honor, I stress again that the prosecution is not saying there was or there wasn't. The Court of Appeal in Kenya, in the case of Julius Kamau Mbogwa.
Just a moment.
Sorry.
You are very fast.
I'm sorry. I was born a quick speaker. I am struggling to go slow, but I'm trying.
Yes.
The court of Julius Kamau Mbogwa versus Republic. Julius Kamau Mbogwa versus Republic. Criminal Appeal number 50 of 2008. Number 50 of 2008. This decision is equally reported on the Kenya Law Reports 2010. And as correctly noted by learned counsel Mr. Awele, that a violation of fundamental rights does not go into the root of a charge. We are again not saying there wasn't or there was. This court has no such jurisdiction. But even if that finding to be made, that violation, which can only be heard by the High Court, cannot go into the root of the charges before you, but is compensatable in damages.
Of objection. Nobody raised the question of jurisdiction and determination of constitutionality of sections. Council is dealing on an abstract matter. My two councils say here they shall follow that elsewhere. So we have not said this court has no jurisdiction. This court should declare the judgment defective or unconstitutional. That is the only matters that were not raised by any of the defense counsels.
Yeah, just to help the court contextualize, when Mr. Malene rose, the first thing he told you is that he was going to give you a context and not the law. However, as he started, the first thing he told you is there is a fundamental issue of Article 27 being in record. So what I'm basically saying
if I bring him clear, Article 49 that defines provisions for compelling reasons is a constitutional.
Let me deal with the question.
No, that the courts here, magistrates, look at Article 49.
Yes.
They apply it,
yes,
but they cannot interpret it. So what we are trying to say is that Your Honor, we are not asking for constitutional interpretations from you, or a finding that is based, or a constitutional finding. All we are saying, apply those ones as the law allows.
Thank you, Your Honor. That admission works for me. I have actually finished my submissions on that. Just reminding you that all the articles of the Constitution that were raised cannot be heard or determined by this court, and we will wait to address. I am done with that question. And Your Honor, we plead with the court to take down that admission by counsel, that they admit you are not the right. Secondly, I now come to the question of the role of the Office of the Director of Public Prosecutions. We have been accused for coming with unclean hands before you. Learned Counsel, Ms. Bashir, contractual maxim, not applicable to criminal law, that anybody who comes to equity must come with clean hands. Anyone who comes to equity must come with clean hands. Even if the maxim were applicable, the obligation to prove has failed to prove that our hands are that, in fact, according to her, we should have been the one to prove that we have clean hands. That's against the rules of it. However, Your Honor, this is very critical considering the context of these prosecutions as established under Article 157 of the Constitution. Has a role that is circumscribed. That role is clearly delineated. I will tell the court one thing that role does not include. It does not include supervisory powers over. Put differently, the Office of the Director of Public Prosecutions is not an appendage, neither of the National Police Service, nor of any other agency in the Republic of Kenya. Why do we say this? Sorry, Your Honor. Questions have been raised as to right to liberty, the arrest of the respondents. But at what point do you trigger the powers of the Office of the Director of Public Prosecutions? The powers of the DPP in exercising the mandate under Article 157(6) of the Constitution are only triggered when an investigative agency has forwarded an inquiry or investigative file. The investigative file, the subject of this matter, was forwarded to the office today, and in record time, around 4 hours, the decision to charge, which in ordinary cases is made within about 14 days. In 4 hours, we had made the decision to charge, and we are before you.
You understand, to help counsel, I know the office of the DPP is vacant and he might be shortlisted to contest for that position. Let him look at Article 157 4. If he will be confirmed as the next ODPP, he has the powers to direct the police. If he is admitting here that they do not have that power, then we have a big problem.
Your counsel is deliberately misquoting me.
Well, unless it's not a
think to his advantage. The powers under Article 157(4) of the Constitution is given, in fact, it's the only power, the rest are mandates, to carry out investigations into alleged criminal activities. That cannot amount to supervision. In fact, you read Article 245(4) of the Constitution, which, sorry, Your Honor, the law in me is...
Be careful, you might be seated there.
So Your Honor, the supervision of the National Police Service is elsewhere, not with the ODPP. And like I have a note, a conveyor belt of charges. For us to come before you today, the Office of the Director of Public Prosecutions Act number 2 of 2010, on which the only test required of the Director of Public Prosecutions, or those of us exercising delegated authority, is whether is evidence with a realistic prospect of a conviction.
Which you don't
We
have.
may have been wrong in making our decision all right, but that is and that's why we have presented charges before you. We shall be expected to bring evidence.
Your Honor, if I... With your kind permission, Your Honor, and just to save the court's time, and my colleague comes from my region, so he'll want to speak a lot, but there is no question about their power or the decision. Absolutely theirs. The question that is before you is that affidavit that denies them bond. They've already taken plea. We are okay with that. We'll deal with that. But compelling reasons, and he's avoiding that because there is no compelling reason.
Your Honor, I have that as my next issue. The court was here when a lot of arguments were made on has violated the Constitution. We have a right to respond to that. That's actually why we're representing the ODPP here. That accusations were made against us. So just like we were very patient with the counsel, let them be very patient with us. It is very important to us, just like it is important to their client's case. So I plead with this court to allow me to respond to all the issues that they raised, and I'm almost done. This point is on the question of Article 49, on whether or not there exist compelling reasons. And Your Honor, we started with the question of jurisdiction. To guide this court with humility, that is the only question that arises for your determination, not the 98% of the submissions from the defense. Your Honor, first of all is the technical question about whether or not the affidavit is dated. It is not. However, a look at page 2 of the application makes reference to the deponent of the affidavit, page 2 of the application. It identifies the deponent of the affidavit, and the affidavit speaks to the grounds in support of the application on the same page, page 2. Those grounds are 1 to 4 on the face of the second page. And finally, on that page 2, the application is dated. We therefore invite you to invoke Article 159 because the affidavit is stamped duly and it is signed. Invoke Article 159(2) and find it proper. For the avoidance of doubt, no application was made to you to strike it out. To the substance, when you retire, Your Honor, you are going to ask just one question. And that's probably what should have come from the defense, and we should have responded to rejoinder, whether or not the prosecution has established any compelling reasons to deny any of the respondents' faith. I reiterate the submissions of my learned senior on the contents of the application and the affidavit. Only to further refer this Honorable Court to clause 4.9 of the Judiciary Bail and Bond Policy Guidelines. Clause 4.9. And more specifically, 4.9c on character and antecedents, 4.9e on possible interference with investigations, and 4.9g on possible interference with witnesses. Those grounds are again on the face of page 2. Just before we go to page 2, the prayers on the application, and then on page 2 we say the grounds number 2, number 3, and number 4. Likelihood of interference with witnesses at ground number 3. Likelihood of interference with ongoing investigations, and finally the possibility of committing similar offenses, which goes to antecedents. Where do we get the facts? My learned senior, Mr. Awele, asks the question, whose reasonable belief? The belief is of one Corporal Geoffrey Mwangi. He identifies that belief in the affidavit, as should be done. What is the source of the belief? He identifies.
Your Honor, this is usually not my ordinary playground, as Mr. Whitty knows it. But I believe the rules still apply. He is supposed to be limited to questions of law in his rejoinder. And I think it is unfair for the accused people for him to start raising or making unusual, factual allusions that will be not an opportunity to explain.
In conclusion,
on that basis, because I was silent, JV, Learned Counsel for the DPP, when on the date of their offer, they never disclose, and this is their charge sheet, unless they are denying it.
That's okay. Your Honor, we'll address that last. I was concluding on the issue of whether or not there's compelling reasons. We invite you to look at a, sorry, Your Honor. Sorry.
The issue that Mr. Owele is
Yes. It is the reason that I have said I'm concluding on that issue so that I don't go on the issues of facts. I think that was guidance. I am very well guided. And in conclusion, we invite you that when you retire and look at the matters of fact on the affidavit vis-a-vis the prayers in the application, you find that indeed there has been established compelling reasons to deny bail. There are 2 questions of law that are left, which I conclude with. Edwin Shisanya Amboso versus Republic is a decision of the Honorable Justice Mugambi that you've been referred to. We have agreed, and it makes sense, that there is a distinction between the orders granted in Edwin Sishanya, which rejected an invitation to declare assemblies unconstitutional or to issue conservatory orders to that effect. The charges before you, 701 of the Penal Code. We admit and agree with the defense that there exists order, the right to assembly.
Thank you.
We, however, are saying that what we have brought before you is charges for alleged criminal offenses. Finally, the question about the dates on the charge sheet. I would have one of them, section 89.5. There was no invitation from the defense or any allegation that there was on the charge sheet. And there's no order of this court rejecting charges, which would have happened under section 89.5. Number 2, of the Criminal Procedure Code provides for an allowance in error of dates and names, among many other errors. And so that reflects the validity of the charges. Number 3, suo motu or upon application by the prosecution to amend charges. That is still available. That power and right exists all the way until before the accused is placed on his defense. In conclusion, I wanted to send a message. I'm only concerned about the message you're sending to the prosecution. We plead with you that we are not we have not shown, or you've not been shown, any fault on our part to send any message. Is to determine under Article 49(1)(h) whether or not there are compelling reasons or not. We welcome it.
Is JV threatening the court?
Issue have been reminded about place of detention. Should this court not be able to to make a determination in the next few minutes. And I have been advised by the leading me today that we are not objecting to the accused persons being held at a police station. However, she's advised me that the police officers will.
Honorable, let me tell you one thing. Off record. The day they'll arrest you, they'll take you to Kamkunji. That is a honorable. When I was dealing with the SSU matter, I'm only talking to him as a friend. This is off completely record. I'm advising him
we
off
can
record.
talk about this off record outside.
No, I'm only advising state officers.
Your Honor, again off record as he sees, he has applied to be my boss. Your Honor, we are done. I'm just the accused persons being taken to a police station. And when you become my boss, we will still do this.
Thank you. No, mine under me it will be very different.
Thank you, Your Honor, for your time.
Your Honor, very. I know it's completely out of order, but I couldn't fail but notice one thing which my learned good friend did mention, that ordinarily the decision to charge takes about 14 days, but they did it within a record 4 hours, which of course we commend, even though we have reason to worry about the speed at which they approved that charge. Secondly, my lord, some of the suspects who were in Mwanguru were also driven here at extremely high speeds. So that means I'm just speaking to the urgency in resolving this matter and still renewing the plea that we made before you. Understanding, Your Honor, that really you've had a long day. But if we can get a decision from you before we depart from this court, greatly indebted to the court. But in the event that then at the earliest, Your Honor, I just thought that this of approving charges within 4 hours should be met with an equally good gesture of this matter being determined within the shortest time possible. So, Your Honor, but I leave it. I'm sorry because I know this is out of character. Thank you.
There's only one more aspect that I'll address you on. The question of the phone belonging to the first accused person. Yes, Your Honor. We'll address you on the day when you come in the next 30 minutes to deliver the video.
Because of the large number of people in the court and the end, they would not have gone up to this point. But I thought if I stopped reading, maybe the reason differently. Some of us would have started making noise. So that's why I have decided to let us proceed up to this time. But it is extremely unusual. So I know you would have liked to have a decision right away. But I'm also asking what would be the effect of that decision, whichever way it goes. If Madam Ukraine is not and it goes in favor of the defense now, and they be able to have the benefit of that decision now, I think the answer is obvious. Yes. So that's why I'm asking to do it tomorrow. We've had a long day and a short night. And by the time we get to our homes, it will be past 10 p.m. So that means the earliest I can start writing the decision is tomorrow. Or even after I finish, I still have something to sign. Many documents still to sign.
Much obliged.
Kirelesho. They came from Wanguru. Others came from Wanguru. Wanguru is very far. Can't go back there. You might even find now there are no vehicles taking them there.
Just for housekeeping, this is now a humble request. It is at night, and definitely each one of us will have to walk out. So I just request as we walk out, just try to do it as peacefully as we can. Because we know that this person will be here tomorrow, and interacting with them at this hour will delay your exit. They know you have to be, regardless of the relationship. And that's that we just take their time and exit peacefully. We will find them here tomorrow.
On behalf of all my colleagues, we wish to take this opportunity to thank the court and the prosecution and the court assistants and the members of the press and the gallery for the magnanimous time you have given to us, and the time and the kindness you've extended to the defense. We are so much obliged. Thank you.
To both sides.
To both sides.
On behalf of the prosecution, your decision was that of Solomon. So we are really indebted and we appreciate it. Also for our colleagues.
Thank you.
You too.
That's very unusual, Your Honor. You're always the first one to leave. But we shall oblige.
This one? Not there.
Media. Hey. Media. Ini ya nani?
Ati.
Enda uchukue.
Mấy ghế đồ căng ghê này. Căng ghê vậy?